everybody's time and attention today. We're going to be discussing the legal risks of IBM licensing, and over the course of the next hour, I will be talking about IBM agreements, the type of agreements that IBM generally considers for its customers, when and how to negotiate terms that are perhaps more favorable than the standard terms available to everyone, what customers should look for in audit provisions, and how to manage large sets of documents that may have been existing with your relationship with IBM over the course of many years. We will also be talking about what happens when IBM acquires a software provider and then begins selling that provider's product under the IBM name. We'll talk about some pitfalls that many customers experience when trying to license IBM products, particularly full capacity and sub-capacity licenses. We will talk about how and when to respond to an IBM audit request. We'll also discuss investigating license compliance internally, which is a good business practice. And finally, we will talk about resolving the IBM audits and what provisions need to be considered when performing an audit resolution with IBM. Initially, I'd like to start by mentioning that IBM agreements are not that easy to understand. They are fairly complicated. The provisions that are contained within the IBM agreements are often interpreted by IBM in a way that is not easy to predict. And so, for instance, it may appear to the customer that the plain language in a license agreement yields a particular result, but when speaking with the IBM audit team or license compliance team or legal team, they all consistently contend that what seems to be plain language is really interpreted in another way. And so it is often difficult from the outset for customers to properly license their IBM products, because it is not that easy to, first of all, find the agreement that relates to the document, gather together all of the license information sheets and license provisions that could pertain to that particular product, and then apply the words, which may or may not be ambiguous, to the customer's actual use in a real-time environment. The provisions in an IBM agreement are typically one-sided toward IBM, which should come as no surprise to folks who have negotiated with IBM in the past. And IBM is often, at least at the outset, unwilling to negotiate heavily. However, if there are certain provisions that the customer finds unfavorable and are particularly important to the customer's best opportunity to negotiate the new, more favorable license terms is at the beginning of the relationship. So what I often find is that the customer is blissfully unaware that it has been using IBM's products in an unlicensed manner for quite some time. And when IBM comes to audit, or IBM's auditors enter the environment to review the deployments and the entitlements, it is only then that the customer realizes that the license documentation and license information sheets and license agreements do not accurately or adequately reflect the customer's need to use the products, and therefore the customer is in a position of trying to retroactively negotiate while in a position of breach, which is sometimes a challenge. So how do you negotiate favorable licensing terms with IBM? The first and most important item that customers need to do when reviewing and analyzing a prospective IBM purchase is to evaluate exactly how the software will be used. And when I say that, what I mean is that the customer needs to identify where in its environment it's going to use the product, what the purpose of the product is, on how many machines will the product be installed, in what type of environment, whether it's virtual or physical, will the product be used, how many folks in the organization are going to use the product, and whether the product will be accessed by any employees, consultants, or other individuals outside of the organization. So all of those categories will be important in the evaluation of how the customer is going to use IBM software. And the reason that is important is it is often the case that the primary issue that's considered in an IBM purchase is price. And during the evaluation, the business team says, we want IBM to give us this product for this price, and it is often the case that the impact, for instance, of a subcapacity evaluation versus a full capacity evaluation has not been adequately explored. And so one of the items that customers should focus on when evaluating whether to install new IBM products in the environment is exactly what type of license will be implicated, and as I'll talk about a little more in a moment, exactly what the requirements will be to qualify for those licenses. If there are ambiguities or gaps in the documentation where the customer does not see that it has the written ability to use the license in the way it intends, then the time to negotiate with IBM about the lack of clarity on that issue is before you buy the license or before you sign the license agreement. When you have money that you're willing to spend with IBM, it is helpful for you to identify and resolve any issues that are present in the license agreement and license terms. If your considered use is not expressly included in the license document, you will have a problem with IBM in the event of an audit. And IBM regularly tells me that they are auditing all of its customers worldwide. And so if you haven't been audited by IBM yet and you are an existing IBM customer, it's a reasonable expectation that a license review is coming. If you are acquiring new licenses, it is very helpful to make sure that you are including in the license documentation and in the acquisition forms all of the rights that you contemplate will be necessary to properly install and use the licenses. Additionally, you'll want to carefully review in any IBM agreement the termination provision. Many customers of IBM's are incredibly surprised to learn that IBM retains the right to terminate the licenses under many circumstances. And it is often the case that the customer has spent millions and millions of dollars to acquire the IBM products and are then in a situation where IBM is threatening to terminate the licenses and command that the client stop using them. It is also important to remember that the license agreement between the customer and IBM is a legal document, and it is very helpful to get an internal or an external legal department involved in the review at the beginning. It is frequently the case that I see with all kinds of software licenses, not just IBM ones, that the customer's business team reviews and signs the legal document that governs the relationship, and legal only becomes involved after the audit has gone sideways and the customer and IBM both realize that they were not on the same page during the course of the relationship. So let's talk about these audit provisions. What are IBM's rights typically? IBM often has the right to enter the office and inspect a business's books and records to confirm compliance. IBM doesn't use that right on its own. IBM typically delegates that right to an auditor, either KPMG or Ernst & Young or Deloitte. And during the course of the audit, it is frequently the case that one of those companies will ask for the opportunity to come to the office to visit with the client's team to determine how the customer is using the IBM products. Another somewhat distressing audit provision that I've seen over the years is some of the audit provisions specifically articulate that if there is a situation that the auditors believe is out of compliance, IBM has the ability, not the obligation, but the ability to ask for back maintenance and potentially interest for either 2 or 3 years. Over the years, I have seen customers successfully negotiate these provisions, but of course, they are always easier to negotiate prior to a license purchase rather than after an audit has begun and the parties disagree. One of the issues that I see in IBM audits is that the auditors receive their instructions from IBM directly. And if there is a disconnect between what IBM believes the customer's obligations are and the customer believes its obligations are, then for the auditor's perspective, IBM wins. So IBM gives the auditor the instructions on how to conduct the audit, and if the customer disagrees, then the auditor's response is, you'll have to take that up with IBM because we're not the arbiter of a disagreement between you and IBM on an IBM license agreement. The unfortunate part is if you have a disagreement with IBM, there really isn't an independent arbiter of the disagreement unless you go to court. And so in a typical audit situation, the customers are clashing with IBM's interpretation of the agreement, and there is no independent party to make a decision about who is right. That is why it is so important when you are acquiring licenses to identify any of the ways you're going to use the products and make sure those are reflected so there's less chance that there will be a disconnect between the customer and IBM. And it's also important to clearly identify who gets to make the final call in the event of a disagreement. Now, many customers of IBM have been customers of IBM for many years. In some situations, I've seen clients who have had relationships with IBM and documents that are still in existence and still effective dating back to the 1990s. As you can imagine, much of the technological language in the old agreements is obsolete. But rather than superseding or replacing the old, potentially inapplicable provisions in the existing agreements, the customer and IBM will simply enter into new agreements. And so there are sometimes 20 to 50 sets of documents that the customer and IBM have to review to trace the entitlements or the ability to deploy products back to the beginning of the relationship. It's further complicated by the fact that many of the personnel that originally negotiated the agreements back in the 90s are no longer still with the company. And so when the company realizes that there's a potential problem with compliance related to IBM products, the customer doesn't really have an opportunity to go back and get insight into what the parties meant when they negotiated the original agreement. Now, while that intent during the original negotiation period is not necessarily admissible in court without an ambiguity in the documents, it is helpful to know where the parties went wrong as they argue about what the licensing terms are and the obligations. if the customer has been lax at keeping up with identifying those changes in personnel related to IBM's representative for the customer, then one of the potential issues that the customer can experience is that IBM can send a notification to the account representative on file for the customer, and that's the customer's internal representative. IBM can send an email to that customer representative that says, we're about to change your license for a particular product, and you have 90 days to object to our revision to your license terms. And IBM sends the notification to the customer, and the customer never receives it because that person hasn't worked at the customer's office in many years. So IBM has just identified and sent to the customer's identified representative a change in the license terms that could have been objected to, but that no one objects to because the email is lost in email outer space. So what can you do as a customer to try to eliminate that risk? Number one, create a generic email address for legal notifications for software, and make sure that one of the people who gets copied on the email to that particular email address is someone on the legal team. And so you can identify as many folks as necessary internally to receive copies of the email message that go to this particular email address, but just make sure that everyone understands if this kind of notification comes in, people need to get the wheels turning to start potentially objecting to the terms that IBM is proposing, because it is typically the case that they are not necessarily favorable to the customer. If the customer does not object, and if there is not a provision in the customer's agreement prohibiting amendments without signatures, then IBM can revise the agreement simply by sending an email saying you can object, and no one does. Additionally, at this point in time, if your IBM customer who is still operating on 30-year-old documents, it may be time to reevaluate and insist that IBM needs to give you a new set of documents that are more up-to-date, that are less confusing, and more comprehensive regarding the products that the customer is currently using. IBM has increased its portfolio every year. Last year, IBM acquired 11 new software licensing or software companies, and clients are often surprised by the fact that when they previously had unlimited license agreements with IBM or with IBM's predecessor, then IBM takes over, releases a new product, and insists that the licensing terms have changed because the customer has installed the newly released IBM product. Whenever a customer receives a notification, or at least notices in the news, that IBM is about to acquire a particular product, the customer's red flags should go up, because it is often the case that this acquisition is going to equal a licensing metric change in the near term, and the customer wants to make sure before the customer installs any updated software that it is fully aware of what the implication of that change may be. It is often the case that customers had a particular licensing arrangement with a predecessor, for instance, Cognos or iLog, or some of those products that often had unlimited or enterprise-wide licenses, and now are on the IBM framework, and there are no longer those types of licenses available. So it is especially important that if you are operating a certain product in the environment and IBM acquires that publisher that the whole team goes on high alert to make sure that any of those licensing updates are fully evaluated from a licensing perspective before they're introduced into the environment. So what types of licenses are we talking about here? Now, IBM, when I've asked them in the past to include lists of all of its products in settlement agreements with my clients, IBM has insisted that they have hundreds of thousands of titles and cannot possibly include a list of all of those products in a particular customer's settlement agreement. And in addition to these many, many types of products, they also have quite a few different license metrics. So I'm going to go over some of those metrics now. First of all, I'll be talking about full capacity and subcapacity licenses. The difference between full capacity and subcapacity is that full capacity licenses are used for physical hardware and for any virtual hardware that doesn't qualify for subcapacity licenses. So full capacity is the default licensing term for IBM, and all license metrics have to be, or all licenses have to be licensed to the full capacity of computers, provided that they don't qualify for an exception. So the most common license type that IBM has is a processor value unit. This is actually a calculation that IBM publishes and that the customer has to make. It is not as simple as counting up the processors or the cores. You have to count them up and then apply a factor to those licenses to identify the number of PVU licenses that are required. IBM also offers authorized user licenses and has certain restrictions on them, including that the named users cannot be reassigned unless the original user is replaced on a long-term basis. IBM rarely, but sometimes, grants the right for concurrent users to use a product, and that is where the customer owns a certain amount of licenses and all of the employees can access those licenses provided that the concurrent number of licenses are not exceeded. And then there are user value units, and those are a calculation where the license requirement decreases as the number of users increase. So we've included an example in the slides that 5,000 users would need 5,000 user value units, but 10,000 users only need 7,500. So as you can see, in the full capacity default licensing set of metrics, there are 4 major and many minor types of licenses, and it's easy to imagine how licensing can get confusing and how customers would have difficulty evaluating their current license capacity at any given time. Sometimes it is too expensive to install the products on a large machine in the environment, and so IBM will offer the opportunity for the customers to identify that they are going to use subcapacity licensing. And what that means is that the customer is only going to license the amount that the product is using or is available for the product to use. So a subcapacity of the full machine will be allocated to the IBM product's potential use. IBM will allow certain customers to qualify potentially for subcapacity licensing, but it is regularly the case that IBM's customers do not understand that they are required to manage those licenses on a regular basis. So basically, IBM requires the customer to identify that it has not exceeded the licensed capacity. How does the customer do that? The customer needs to have an ability to review at any time the amount of the servers that are using a particular product. IBM requires that measurement tool to be its own IBM license metric tool. It's also called ILMT. Many customers are unaware of the requirement that ILMT must be installed. So in an audit, the audit team will come to the customer and say, do you have a virtualized environment? The customer's answer is regularly yes. The auditor will then say, do you have ILMT installed? The customer's regular answer is no. In that situation, the auditor will calculate only the full capacity of the licenses, or the servers, excuse me. So the auditor will calculate the full capacity of the computers that are available to the IBM products and prepare a report that typically shows that the customer is under license. The customer believed that it qualified for subcapacity licensing because it was unaware or didn't remember or couldn't properly install ILMT, and therefore dispensed with that requirement and went on with buying enough licenses to cover the subcapacity of the server and running the licenses in an environment that would require full capacity licenses. This is the single largest issue that I encounter in IBM audits. It is regularly the case that customers do not understand this requirement or believe that if ILMT isn't working properly, that they can dispense with the requirement and proceed on a subcapacity basis anyway, which is simply not the case. Furthermore, some companies do actually install the ILMT product, but do not prepare the monthly or quarterly reporting. There are two different kinds of reporting requirements depending on the type of license agreement that the customer has with IBM, and the customer has to, for the full amount of time that the products are installed in the customer's environment, and for the full amount of time that subcapacity licenses are being used, the customer has to generate reports showing that at no time during the reporting period did the subcapacity license entitlement get exceeded. So you can see that this is very complicated and a huge source of confusion and consternation among the customers when IBM auditors just ask a yes or no question at the beginning of the audit and determine that there is no entitlement to subcapacity licensing because the license metric tool has not been installed. How does a customer respond to an IBM audit? One of the ways that the customers can effectively approach an IBM audit is to understand from the outset exactly the scope that IBM is requesting. And if the scope is objectionable, curing any of those questions about the scope before the auditors begin. So IBM may say, we want to audit all of your usage worldwide. And if that is not okay for legal construction or for the division of the corporate structure, those objections need to be identified at the beginning before any data is produced to the auditors. Second of all, with respect to the auditors, many of my clients have objections to which auditor has been selected. So for instance, many of my larger companies have Deloitte as their external auditor, and they feel uncomfortable being in a potentially adversarial or at least disadvantageous position with Deloitte in a software audit. So many of my clients who have a particular auditor for their independent accounting purposes object to the selection of the auditor when that auditor is intended to be used as the auditor in a software audit. And then the third item that is not necessarily required before the audit gets started but will become a question very quickly is whether an on-site meeting is going to be allowed with the auditors. many of my healthcare clients refuse to allow on-site meetings, and sometimes there are opportunities to work around the on-site meetings, but in many instances, the audit cannot be resolved without one. And so it may be the case that the customer has to be creative about how the on-site meeting is going to happen, where, if it has multiple locations, is it going to take place, who needs to be there, who needs to stay away, and how the parameters of the on-site portion of the meeting will be communicated to the auditors. Because there's a possibility that there will be an on-site meeting, and because many of the documents that may be accessible to the auditors could contain confidential or private information, it is important before the customer provides any substantive information at all to IBM or its auditors that the customer has a confidentiality agreement with the auditor. And one of the provisions that we fight about a lot in the confidentiality negotiation is under what circumstances does the auditor have the ability to release the data to IBM without the customer's consent. So one of the problems that the customers experience is that once they've given the installation data to the auditors, if they're unhappy with the auditor's conclusions based on the installation data, IBM will give them a limited amount of time to make objections, and then IBM will request that the auditor send the report. The customers are often disappointed that they did not have what they consider to be an adequate amount of time to identify and object to certain conclusions in the license reports prepared by the auditors. Additionally, IBM will ask for a identified time frame, and if the customer has concerns about the time frame, they need to be raised when the time frame is originally presented. It is regularly an issue where the customer agrees to the original time frame, not realizing that the extent of some of the requests that the auditors have made or will make, and when the customer gets behind on responding, then IBM can say you agreed to this time frame, and we think your audit is off track because we asked you to commit, we gave you time to consider, you didn't object, and now you're behind. It is typically the case that if you're fighting about the time frame, you need to have good business-specific reasons why you might be delayed. One of the common issues that comes up in the discussion of the time frame or the discussion of the scope is how the customer is going to collect the data that IBM and the auditors are requesting. And when you are considering how to collect the data, keep in mind that IBM is going to have some suggestions for how to do that. So when you're evaluating time frame, also evaluate all the requests that you have so that you can object to all of the objectionable items at once. Will you be allowed to uninstall the products as a result of negative audit findings, or will you be forced to buy those products? The answer is not always. You will not always be able to uninstall them, and you will not always be able to be forced to buy them. But it's typically a hybrid approach where IBM will require you to buy the value of the licenses that you were short and use those for products that you may need in the future. In some instances, it's non-negotiable. In some instances, if there's a deficiency, you have to buy those products. It is never the case that you can uninstall the products and not pay anything to IBM as a result. That is simply not an option. But what's most important is because you may have multiple agreements with IBM, if IBM is telling you that it's auditing the scope of all of your products, you have to go find the license documents for all of your products and identify what the audit terms are for each one of those, because it could make a significant difference. If you're not under an audit, how are you going to determine what your license position is? It's a very good idea for IBM and other software publishers' customers to regularly evaluate their environment and to identify what, if any, questions or concerns they have. And I just want to interject here an issue that I've seen coming up very regularly over the last couple of months, which is if you do have a question about an audit process or an audit interpretation or a license interpretation, who do you ask? Who do you ask about these questions? Some people, some customers ask IBM directly, and they say, we have a question about licensing, and we need an answer, please. And they get an answer from a representative at IBM, and they rely on that answer, and then they proceed with their project. And in an audit, that discussion will be completely irrelevant if it wasn't written down and isn't in the form that would be considered to be an amendment to the license documentation. So it is perfectly fine to call IBM and ask them for their advice about licensing, but make sure you follow it up with a writing that's sufficient to constitute an actual revision to your agreement if it's different than what the agreement says. Additionally, many of my customers have recently been surprised to learn that the information they got from their reseller about licenses is wrong. And when that happens, IBM will not say, we are very sorry that our reseller told you the wrong information. We decided that based on that, you're not going to be liable. That is not what happens. IBM will say, we're very sorry that the reseller that we recommended gave you the wrong advice. We're going to address that with them. But in the meantime, how would you like to pay us for the license deficiency that we found in the audit? So it is okay for you to ask a multitude of sources about how to interpret the license agreement, but it is very important that if you're going to rely on that interpretation, particularly from IBM or the reseller, that it constitutes a revision to the license agreement. Otherwise, it may be an unpleasant surprise when the audit team doesn't believe the licensing team or the sales team on a particular IBM contract interpretation issue. So once you have the opportunity to review on an internal basis, what steps will you follow, and what challenges will you face? First of all, as many large customers know, it is very difficult to be able to, on command, produce a set of reports that document all of the installations of any given product. It is difficult to validate in large environments. The discovery of the assets is challenging. Some of my clients don't even know where all of their assets are. They're mobile and they're being carried all around the world. And validation is difficult because many different teams may manage the environment. It is critical that the organization for each major publisher that they have, including but not limited to IBM, has a process in place that would allow the customer to be able to internally investigate its license compliance. That will make it so much easier if one of the big publishers like IBM comes along and says, we're about to audit you. The customer can say, good, we just audited ourselves. How would you like us to deliver the audit information that we already have? It's also a good idea just to regularly double check and make sure that the customer is in a position to identify any potential licensing questions so that they don't come up during an audit. So once we understand that discovery of the assets is challenging and the reporting is unreliable and the validation is difficult, and that IBM recommends or requires ILMT when subcapacity licensing is in use, then what are we going to do next? First, we're going to make sure that any of the reports that the customer is preparing internally is protected by the attorney-client privilege, either by working appropriately with in-house counsel or with outside counsel to make sure that those data points are not something that can be discoverable if possible. Now, that's not always possible when there's not an audit or a threat of litigation, but when it is possible, it's helpful to use that process to protect any of the data that are being generated. Once you get through all of those hurdles on the deployment side and you actually have an opportunity to identify what has been installed in the environment, how are you going to find out what the customer owns? That is sometimes even more difficult than the deployment for the reasons that I've already discussed earlier in our talk today. One of the big reasons is that the contracts often contain the entitlement information, and if you have contracts that are many, many years old, it may not be clear how those entitlements can be used in today's environment. Additionally, I regularly see challenges with identifying, locating, and interpreting old agreements for IBM's predecessors. So for instance, IBM purchased Cognos, and now customers who are continuing to use Cognos have to determine whether it's the current IBM Cognos agreement or the previous Cognos agreement that will govern the relationship, and that is not always as easy as it seems to identify. One of the ways that many customers try to tackle this is to look for proof of entitlements and collect any support invoices so that you can see what you've recently acquired. IBM's proof of entitlement does not always constitute an acceptable proof to IBM, but it is a really good start. And so once you've determined what you have installed, then you have to compare it to what you can prove that you have the ability to use under the contracts, the purchasing documents, and any other entitlement information that the customer can find for their particular organization. Once you have a good sense of what you have installed and what you can prove you own, then you can work toward producing the information to the auditors if there's an active audit. And once that happens and you've produced the requested data to the auditors are going to evaluate that data and present it in a preliminary form to the customer. It is really important that once the customer gets that preliminary reconciliation report or effective license position or deployment to entitlement summary, those are all names that the auditors use. Once the customer receives that primary and preliminary report, it is very important that the customer then review it for accuracy. The auditors often misunderstand communications. The auditors often misapply the licensing rules, or the auditors often miscount. And so any of those items can result in a higher potential exposure, and you want to make sure that before you start to resolve your IBM audit directly with IBM, that you've had an opportunity to present to the auditors any of the objections that you have. Now, keep in mind that what I said earlier is still true. If you have a dispute with the auditor about what a license provision means, then the auditor at best is going to record an objection and send the report to IBM. It is unlikely that your interpretation of the license agreement is going to prevail over IBM's in the report that IBM's paid consultant prepares. So you want to make sure that you've effectively preserved the arguments for presentation to IBM, because when the auditors are preparing their preliminary report, they have not yet released it to IBM. So you want to make sure that their math is right, that their analysis is right. If there are any disagreements that you have with the way the materials have been presented, make sure that you identify those and ask for those to be reflected in the DES report or the ELP or the reconciliation report or whatever the auditors decide to call it. Make sure that all of your all of your objections are accurately and adequately presented. It's usually the case that IBM either calls or sends an informal note with the audit demand in the quote, and IBM will ask for the customer to pay the requested amount within 30 days. In many of the IBM license agreements, the 30 days is specifically enumerated as a requirement. If there's a discrepancy in licenses, the customer has to pay for all of the identified licenses in 30 days. The license agreements do not typically say you have to pay for the undisputed amounts or the amounts with which you agree. It usually says the amount demanded. Now, it is sometimes the case that the amount demanded may be subject to consideration and adjustment by IBM for various factors. It may also be the case that you can say, I don't need one particular product, but could you help me with a different product? And IBM may potentially allow substitution in some limited cases. But however you resolve the matter, it is most important to ask for and to get a release. And it is sometimes the case that the IBM representatives will try to convince you and your team that you don't need a release. But it is perhaps the most critical component of an IBM resolution is that, number one, you get a release for any claims they used to have, and number two, you make sure that the documents going forward that are going to govern the relationship between you and IBM are documents that accurately reflect the relationship that you'll have with IBM going forward. So it does you no good to get a release and to then immediately put yourself back in a situation where you are not compliant with the license agreement because there is still a disagreement between you and IBM about how to apply a particular provision or how to use a particular license. So one common example of this problem is my clients will get a release and they will then continue to use subcapacity license agreements, subcapacity licensing rules without installing ILMT. And that puts them immediately in a jeopardized position because ILMT is still required. Because they got a release for their past use of the products without ILMT does not mean that they've revised their license agreement to absolve them of the responsibility of using ILMT in the future. And so it is very important for all IBM audit targets to make sure in the resolution that your existing go-forward documents eliminate the disagreements that the customer has with IBM and also releases the customer from any liability that they may have had with IBM. There are a couple of items that I just wanted to go over using a case study example. One of the examples is that the customer has many different types of IBM agreements, and there are several problems, but the original, the biggest problems associated with this particular customer's environment are the three that I've listed below. So I'm going to talk about these potential issues, and then I'm going to talk about some possible resolutions, and then if time permits, I'll address some of the questions that we have in the question box. So the customer, as I said, has a number of different types of IBM license agreements, but nobody can find the original agreement that governs the original purchase. So you have a situation where the customer believes that it has the licenses for a particular product, but it cannot prove so. The second issue is that the customer virtualized its environment, and someone on the team understood that they could only license the capacity of the virtual environment that was using the IBM products, and nobody installed ILMT. And then the third issue is that IBM sent to the customer notification that said, "Dear Bob, we're changing your licensing terms, and if you don't like our new terms, you have 90 days to object to the new terms." Bob hasn't been with the company in 10 years, and so Bob did not object, and no one objected because no one actually received the notice. So what are we going to do about these three potential issues that that we identified with a pretty average IBM customer? Well, the first thing that you're going to do is consider updating to a master agreement, and this master agreement will incorporate everything that you are currently using as an IBM customer and clearly articulate what you can do with those licenses and what you can't. And as part of that negotiation process, it may be the case that you want to consider including a statement from IBM recognizing that you both understand you have these old licenses, and even though we can't find the original purchase documentation, we can certainly show that we've paid maintenance on these licenses for the past 15 years. With respect to ILMT, it is sometimes the case that my clients find that they either can't install ILMT effectively or they don't want to go through the process of installing ILMT. So if it's the case that the team bought the licenses believing that they could license on a subcapacity basis, and really they don't want to or can't install ILMT, we need to determine whether or not we have to go back to full capacity licensing. So it's sometimes the case that IBM customers determine that it's better for them to isolate their IBM environment in a physical network than it is for them to try to install and run ILMT on their virtualized network. So that's something that needs to take place, because if you are running subcapacity licenses without ILMT, it's a potentially significant exposure item. And then some of my clients have been successful in including terms in the IBM agreements in the past that have limited IBM's ability to revise the customer's environment or the customer's license language without the customer's approval. This is a tricky one because in some of these license agreements are 15 to 20 years old. It specifically says that IBM or the customer cannot change the licensing terms without both parties signed consent. But then IBM releases a new product that's not covered under that license agreement, and the new license agreement says they can change it any time. And so you have to make sure that you're especially diligent if you were successful in negotiating one of those provisions in the past, that you are not in a position where you are allowing IBM to change it for future releases or for new products. So those are some suggested resolutions to the potential case studies, and now I'm going to address some potential questions that the users have sent during the call. Bear with me for just 1 second. It's a little small to identify the question. One of the questions is, has IBM's interpretation of its contracts ever been tested in litigation? Not that I'm aware of. It is often the case that what happens is IBM and the customer have a disagreement about the license terms, and the customer, when it receives the threat of termination, decides to proceed with negotiating a settlement rather than continuing to fight with IBM because there's not necessarily an independent arbiter. One of the questions is it appropriate to demand that IBM or its auditors produce all of the documents that define IBM's audit rights? Yes, it's appropriate, but if you do request that they identify their audit rights, what they're going to tell you is, please refer to the IBM Passport License Agreement, the IPLA. All of our rights are in there. And so if you are trying as a customer to say that you're not subject to the IPLA and instead you're subject to custom terms that apply only to you, you need to have that license agreement available so that you can be ready to defend yourself when IBM says that it doesn't agree with your interpretation of its audit rights. The next question is, will we be able to get a copy of the slideshow? The answer is yes. It should be emailed to everyone, and if it's not emailed to everyone along with the link of the recording, then you can reach out to Diana Peterson in my office, and she'll be in a position to get you a copy of the slide. Let's see. The next question is, you mentioned qualifying for ILMT use. Who do we get final feedback if we qualify? If you are trying to use virtualized environments and license on a subcapacity basis, you have to use ILMT. There's very few exceptions. They're listed very clearly in the license documentation, and you can review the license agreement to determine whether or not you qualify. But for instance, it's if you have less than 1,000 PVUs, or if you have less than a certain number of users. And most companies that are virtualizing and are trying to use subcapacity licensing just don't qualify. The next question is, do you have any suggestions for instances where IBM is trying to change licensing for a legacy product where only active users were defined, thus inactive users were limited, and now IBM is requiring the customer to make an election and purchase additional inactive licenses? I do have suggestions for that, but it's pretty long and we're a little bit limited on time. Primarily, I would say that that if you're trying to apply legacy licensing terms, please make sure that you're still using the legacy product. If you've upgraded to IBM's release of the product, your argument is definitely weaker about applying the old licensing terms to the new licenses. And I have time for one more question, and then I'll hand it back over to Marcus, who says, two-part question. Sorry, excuse me. I'll hand it back over to Marcus after I answer one last question. You mentioned that ILMT does not work properly. Who do we refer to or consult with if we find it's not working or reporting accurately? This is a very common issue, that ILMT doesn't work in a particular environment. You could reach out to IBM, but just make sure if you don't have it installed, you have to license on a full capacity basis until you get it installed. There's no exception for the time when you're trying to install ILMT. So just make sure that you're aware that until you can install ILMT successfully in your environment, you are not allowed to license on a subcapacity basis. I appreciate everybody taking the opportunity to visit today on the webinar. I hope you found the information helpful, and now I will turn the meeting back over to Marcus Alexander so that he can provide the CLE information. Thank you, everyone.